Hello LiveLaw viewers, I am your host Urvashi Chauhan and I am back with another interesting episode where we talk about all things happening in the legal world. Well, today we are going to be talking about something crucial. Recently, Supreme Court has delivered an important judgment which talks about recording of appearance of advocates before the Supreme Court. But before we go into what the judgment is about and the related aspects, I want to give you a little background context here so that you can understand what discussion we are going to have about. In the Supreme Court, there are different categories of advocates, those who practice, namely the designated senior advocates. These are recognized under Section 16 of the Advocates Act. There is a full process that follows how a senior advocate is designated, but basically, depending on the standing at the bar and the experience and knowledge of a person and years of experience determined, and on basis of that, the Supreme Court gives this special distinction to certain advocates, those who are designated as senior advocates. Now, as a part of some restrictions on these advocates, the senior advocates cannot file cases directly and they cannot accept briefs from clients directly. So there is another set of advocates who brief the senior advocates called the Advocate-on-Record or the AORs. Now, in order to become an AOR, one must pass an examination which is conducted by the Supreme Court, and to be able to be eligible for this exam, the lawyer must have at least 4 years of practice and 1 year of training with an AOR who has completed at least 10 years of practice. Apart from that, there are non-designated senior advocates and there are junior lawyers who are assisting the senior advocates or the AORs, etc. Now, the question on the controversy comes that when these lawyers are appearing in the court, whose appearance will be marked in the court proceedings? As a matter of practice, like I said, that the senior advocate cannot file cases directly. So whenever a senior advocate is appearing in the court, he will always be assisted by an AOR. The senior advocate will have his own lawyers, his own juniors who are appearing or assisting him, and the AOR will also have his set of juniors who are assisting him in the background, maybe for research, for filing, etc. A lot of things. Now, like I said, the question comes, whose appearance will be marked? Now, recently, court found that, whenever a matter is being heard in the court, so all the people, all the advocates, those who are part of that particular case would give their names in the appearance slips to the court masters and their appearance would be added. As a result, in the court proceedings or in the court orders, there would be pages and pages of names of advocates which would appear. And the court also recently noticed that there were some advocates who were not physically present in the court, but still their appearance was marked. The court took this up very seriously, and as a result of which this judgment was delivered. Let me tell you, this judgment has been delivered by a bench led by Justice Bela Trivedi, and the crux of the judgment is that during the hearing, while the hearing is going on in the court, the senior advocate, the AOR or any other advocate who's appearing, only their appearance will be marked. Plus, one assisting advocate or AOR can be present and their appearance will be marked, but of none others. Well, this has opened door for some speculation and some debate, especially with respect to the junior lawyers, those who work in the background for assisting the senior advocates or the AORs, as to, if they lose on the appearance, how that can affect their professional career. So this is what we are going to be talking about today and some other aspects of this judgment. I take pride in welcoming and introducing our guests for today. My first guest is Ms. Srishti Agnihotri. She's an independent counsel and an advocate on record. Her area of practice includes constitutional law and environmental law. She practices in the Supreme Court and various high courts, and she practices in various matters, including the rights of disadvantaged groups. Welcome, Srishti. Welcome to LiveLaw.
Happy to be here.
We also have our second guest today, Advocate K.R. Shiyas. He is presently working with Advocate Prashant Bhushan. He started his practice in the year 2021 with a senior advocate, and he is also the co-founder of Nyaya Niti Foundation, which is a pro bono litigation firm which provides legal assistance to the marginalized community. Welcome, Shiyas.
Thank you.
We are also being joined by my good friend Anna Oommen, who is presently practicing with a senior advocate. She has more than 2 years of practice, and before practicing at the Supreme Court, she was practicing at the Bombay High Court and the district courts in Bombay. Welcome, Anna.
Thank you, Rishi.
Well, when we talk about this topic, like I said, the first question which I want to ask you, because we have quite a balanced panel today. We have an AOR, we have somebody who's assisting a senior advocate, and you are with quite a renowned advocate, but who's not a designated senior. So the first question which I want to ask, and I'll start with you, Srishti, is that, how does this judgment affect you and the others like you?
So I think that's an excellent starting off point. And I would say that there are two ways in which this judgment affects us. So one is the very practical difficulty. In any AOR's chambers, there may be one or two junior advocates or colleagues who will be doing a lot of the preparatory work. So there may be somebody who's researching case law. There may be somebody who's prepared a list of dates, gone over the voluminous pleadings, prepared a briefing note. And the question then becomes, you almost have to sort of choose. These people don't really get their work acknowledged in a way that can be very motivating for a young person. Okay. To see your name reflected in an order in a matter on which you worked hard. Obviously, this is the one operational difficulty. But the second thing also, I think it speaks to a conceptual understanding of what litigation is, right? So does it matter that there's one person arguing and one person that's assisting? Is that all? Because ultimately it's also a collaborative exercise where different people take ownership of a matter in different ways. So it also sort of makes one question that does this view that you have to have a very restricted number of people whose appearance is recorded, even though others may be present in court, may be assisting, does it also take a very narrow view of what a litigation team does?
Yes. And the scope that you're talking about, we'll come to it towards more. I have some more points to add to that, but I'll come to Shiyas first to please continue.
So there is no doubt that this particular ruling of the Supreme Court will affect the junior advocate, those who are not AOR and those who are not an arguing counsel. So first of all, I have to tell there is two problems in the particular judgment. How it will affect the junior advocate. One is the inclusivity and other accessibility and recognition of the particular junior. So inclusivity matters when somebody put their labor. Labor is not just a physical labor, sometimes cognitive labor also should recognize by the particular field of practice. So whenever somebody get alienated or someone's name would not be getting recorded in the particular order, their cognitive labor will get replaced or replaced by the only three people, that one senior lawyer, if the senior lawyer appeared, and another AOR, and only one assisting lawyer. Mm-hmm. Second thing is the recognition of a junior lawyer is very important in his career growth. Not just for the next few years, it will affect his senior designation in the future, his credibility in the bar, his presence in the bar. This entire, holistically, this particular ruling will affect the growth of a particular young lawyer, especially first generation lawyers.
Correct. Coming to Anna.
As a junior in a senior's chamber, a junior has two main roles. One is researching on the particular point of law, and secondly is to prepare a short brief note. So a senior's junior is also completely involved in the matter as equal to an AOR who is coming to brief a senior. The AOR and the team of AOR briefs the senior, and then it is the junior who prepares the brief note and the research point. So I am also an assisting counsel. So with the direction of the Supreme Court, they say that only one assisting counsel's name should be added in the appearance. So who becomes the assisting counsel? Is it the juniors of the AOR or the juniors of the senior? So this is a question that we have to.
I think they have mentioned for each in that each for one can be, but still again, I think these are some valid points that you have raised. Like we're talking about it and so much hue and cry about, appearance. So I want to ask you, like, what is the importance of appearance? Like, Shiyas mentioned that it would be, important when you are designated as senior and other things. So what are the other, aspects which are important with, appearance, the appearance being marked, apart from, of course, it forms a part of the court proceedings?
So I think one very important thing is chamber allotments. So the number of times that you've appeared, when you're applying for a chamber, the fact that you're a regular practitioner in the Supreme Court is shown through these orders where your name is recorded in the appearance. Another important aspect would be voting, that you're a regular practitioner in that court. The appearances speak to that. Then obviously there's the issue of senior designation. And I think also it's but very importantly, it's an acknowledgement of your, I also think that yes, it has practical implications on prospects like chamber designation, but it's also your credibility. Imagine if somebody has worked 14, 15 days for a final hearing for a matter, they've assisted, and at the end of the day, you're letting young people walk away with the feeling that there's no record of the effort that they've put in. So I also feel like we shouldn't understate that. But yes, there are all these practical implications also.
Yes, I think to also apply to panels, you have to show certain appearances. So if you don't have that, it will be very difficult for a junior to apply for these panels. One more thing, when we apply to different offices, different chambers, and we mention in our CV that we have worked on so-and-so matter. But if we go to a chamber and if we are asked, okay, show us those orders, and if our orders are not there, how are we supposed to prove that we have worked on a certain matter? Because we will easily get the, we can learn the matter and brief the matter. But what about our appearance? How do we prove that we have actually appeared in that matter?
And I think there is no hard and fast rule that only one lawyer should assist a counsel. Because in an office, for example, office like the office which I am working, certain times maybe all states would be the party in a matter. So recently in one of the important matter in the Supreme Court, all states were the party, including the union government. And we know through various reasons, this state council will share the proof of service or the copy of the particular status report or counter affidavit, whatever is it, just 2 days before the hearing or just 1 day before the hearing. So suppose if the particular affidavit consists more than 150 pages or 100 pages, it will run out of more than 1,000 pages, and it is not humanly possible for one person to decipher what is in it. Yes. And in certain occasions, we junior counsels create a table for judges as well as seniors as well to get easy to analyze the particular counter affidavits. So if only one person works, and most of the time more than 1 or 2 advocates work in the particular affidavits, but unfortunately due to the ruling of this honorable court, only one person get recognized. Yeah.
Yes, and
I just wanted to add something. We're just thinking out loud here. If you're also, there's a problem of conflict. So suppose I work in ex-seniors chamber. I've worked on a matter, I'm privy to the files, I'm privy to legal strategy. My name is not there in the order. But tomorrow, I join Y seniors chamber who's appearing in that matter against ex-senior. Against that party. Right. My name is not in the order. So I can sit and I can, in a way, this recording of appearances also enforces accountability.
Yes. That's, I think, a new angle which has, come, it's important. And also, the first point that you had mentioned, that it is important for allotment of chambers and all. In fact, the MA that was, raised by the SCORA and SCBA, the MA that they filed, there also they had mentioned this point, but, unfortunately the court dismissed it actually. But anyways, moving further, like you're all practicing going to the court every day. So it's a normal thing. Everybody knows that every lawyer, be it an AOR or the senior advocate, they will have more than one matter in a single day. And in places like Delhi and Supreme Court, where, a lawyer would be present in Supreme Court as well as the High Court. So how will the lawyer be physically present? He cannot be physically present at one time, in more than a single court. So this will either he will have to ask for a passover, an adjournment in the matter, because his presence will only be, his appearance will be marked only where he is physically present. So how do you think, don't you think this creates another barrier?
So I think in critiquing the judgment also, we have to be careful about one thing that the judgment has flagged, which is correct, which is that I don't think people who are not in court or not like you were maybe rushing to court and for unavoidable reasons you couldn't reach there on time. But if you're actually not in court and not planning to be in court or know nothing about the matter,
Yes.
your name should not be there.
Yes.
And similarly, if a person has not been able to make it to court physically, though they were planning to, they should inform that we weren't there. And we used to have a system where the courtmaster would note NP. So suppose you give a appearance slip and it's got a senior's name and he's not there, the courtmaster can obviously see that, because a senior they can easily identify, and they'll say not present. So similarly for the others who were maybe planning to be there but couldn't be due to a clash, they can intimate the courtmaster, and I think that is an important aspect.
Another problem that judiciary itself is facing, that the hesitance of the young lawyers to enter to the litigation. So such a restriction will deter someone to join the litigation itself, because if my work or my effort is not getting recognized, and then obviously the person will have some hesitation to join the legal practice.
Another question and aspect which comes to my mind is, with respect to constitution matters or the 3-judge bench matters, where, the matters are so lengthy that by default there will have to be multiple lawyers involved, So in such cases, how do we balance it with this judgment?
Urvashi, actually in constitution bench matters, what happens is there is a team of juniors who work on that particular matter for months together. And then there's just one thing that we want, कि हमारा appearance आ जाए उस record of proceedings में. But there is one more issue, that in constitution bench matters, we have seniors from various high courts who are coming to the Supreme Court also with their team of lawyers. तो इसमें किसका appearance mark होगा? Because you're only giving it to one assisting counsel of AOR and the senior advocate. So they will automatically lose their appearance in such, high profile and constitution bench matters.
Certain cases, sometimes counsels from the lower court, like high courts or the trial courts, brief the senior or the AOR. Then it's a chain of events, it's a chain of communication. So due to this judgment that communication or the visibility of those people who are in the communication get disrupted. So I think the Lordship had to consider those aspects as well. Those lawyers who are briefing the lawyer in Delhi from other part of the country as well.
Anything you'd like to add?
Yeah, I certainly think that different matters call for different approaches, but I also feel like maybe the concern that the court had was who's certifying that these lawyers are actually involved and these lawyers are actually authorized by the client and are appearing. So I feel that the institution of an AOR is an important, they play an important role. So an appearance slip is always filled in by an AOR. And ideally, the AOR is supposed to check that whoever's appearance I'm putting in, that person has actually worked on the matter, that person was actually present. And I think that should take care of, if that's responsibly done, that should take care of any fears.
So the accountability should be on the AOR.
Correct.
That would solve a lot of...
because the appearance slip anyway is given by the AOR.
Yeah. So taking a cue from this, this judgment, if we go a little into the background, we know now in this judgment, there was something strange that happened. At LiveLaw, we termed it as the fake SLP case because, the petitioner himself wrote to the Supreme Court registry saying that he had no idea about the matter going on. And then this matter has a political angle and it is related to a high profile murder case also. So of course we understand the concern of the court and where it is coming from. But how do we balance this with the concerns of the, the lawyers that, the junior lawyers and etc. that we're talking about? Because of course, we have to somehow, don't you think there has to be a balance between, the genuine representation as well as this unnecessary name dropping? What do you think?
Correct. And I think that name lending or lawyers giving appearance in matters where they have no connection with the case, that's always going to be a problem. And the solution, I think, is in better training, accountability, and one should also, I think this MA that the Bar Associations, the SCORA and SCBA filed, is also an interesting example of a dialogue that's taking place between the bench and the bar.
Right.
And the fact is that we have to evaluate how we look at the role of the bar? Do we look at it with suspicion? That you are going to try and put in names, there's going to be name lending. Yes, those are realities. But then we have to perhaps also see that there are so many lawyers who are genuinely invested, particular, and any sort of policy decision that comes out shouldn't have a demoralizing effect on lawyers who are working very hard on matters.
Yes.
I agree with you on the point where, people who have genuinely contributed to a particular matter, they should definitely have their name on it. But then through this judgment, do you think that limiting number of appearances is actually the solution?
So I think that's interesting. And I think the court was faced with, when they looked at the rule, they saw the noting under the rule, which is also something we were discussing, that the court masters should ensure that only the senior advocate who's physically present and arguing, and an assisting counsel, their name should be recorded. Now, I think the emphasis was on only and physically present, but I do think that rule was it came in 2019. Now, the question is the amendment to the rule. And the question is, so when we're talking about appearances through virtual mode, does it fall within the ambit? So obviously you'll have to interpret physical presence broadly, because now there's a new reality. We have virtual appearances and those are permitted. Similarly, only counsels were assisting. There could have been a way in which the word assisting could be interpreted to mean more than
many
one.
things.
People are recognizing the reality of a Supreme Court practice.
I think SCORA itself proposed that assisting counsel, briefing counsel. That's a good suggestion.
Well, as we're moving towards concluding this discussion, this wonderful discussion we've had, in between, I think we had brought up this point and I want us to discuss a little bit more about it. So eventually, there is one, a bigger angle to this thing, which should be looked at, and let us deliberate on, whether the court has looked at that angle or not. So we all agree that this judgment discusses some important issue. Whether this issue, has been resolved by this judgment is open for speculation. But I frankly do know some people, those who have, like you also mentioned, that they have nothing to do with the matter. They have not even read the case once, but just to, sometimes put it on probably LinkedIn, on social media, to show that they appeared, they're doing it, and which, of course, we would agree is not correct. So again, the question here comes is that, how do we deal with issues like this? Could there be, a way? Recently, I was having discussion with one of the advocates, and they said that, there could be a way where judges could ask some questions from the lawyers, those who are appearing. Okay, they could ask some questions and know whether the lawyer who's appearing, whether he's familiar. Of course, he does not have to argue the matter, but is he familiar? So do you think some things like this, and for people, those who are, misusing or giving false appearances, could there be some strictures for them?
So I think we have to be very careful about having any sort of one-size-fits-all approach. I am a firm believer that people setting good examples, there are AORs who, when we were young, who we used to look up to, we try to model our behavior after them. I think that obviously there has to be rigorous training. People have to make sure that good practices trickle through to the younger generation. I don't know if strictures and punitive action necessarily helps, but certainly the court has to take a serious view if any such misuse comes before it. Yeah.
The idea that you gave, that judge should be asking, means in some matters can ask the juniors that just argue for a minute or so. I think it's a wonderful idea, but I also think it's time consuming.
Yes,
every time it's not possible. But in constitution bench matters, it's definitely possible. In fact, the former Chief Justice also in multiple occasions actually has encouraged juniors to argue for a minute or two just to test their familiarity with the case or no.
Yes.
Yeah.
And then if they're appearing,
and that actually helps. Yes, exactly.
Yes, it does help. Yeah.
So yeah, it's a good suggestion, but from the point of a client, I also have certain, even if I'm not a client, but I just speculate that because clients knows that Supreme Court has only a very few minutes to argue, and suppose if there's some junior appear in that, or if some junior make a submission, whether it will hamper my case, it's because of the junior submission my case got hampered. So we have to consider all these aspects. And also one thing you mentioned about the social media promotion, the individual promotion of lawyers. So that is it is a duty of a BCI to take such corrective measures. And there should be a proper dialogue. We cannot ignore the reality that things have been changed, and now the different mediums are there to promote or advertise themselves. So BCI has to take a good call, and there should be an open discussion with the stakeholders.
One idea, I think, modeled on the kind of suggestion you made, is to perhaps have a random sort of system where after a given number of days you randomly ask one AOR that, look, this appearance was submitted in this matter, please clarify that everybody was either present virtually or physically, and clarify their role in assisting in the matter.
Yeah, and that would have some sort of a deterrent at the back of your mind, that you could be questioned. Indeed. I think, those were some really good points that we discussed, and it was a great discussion on this particular topic. Thank you so much, viewers, for watching. You can go to the LiveLaw website and read about this judgment. If you have any opinion, any suggestions from your end, please make sure to put it in the comment box. In case you want us to make some videos on any particular topic that you think that we should discuss, please make sure to put them. We would love to hear about your views, and make sure to like, share and subscribe to our channel. Please share this video with all the people in your connections, and for more such insightful content, keep watching LiveLaw. Thank you.